All right, Mr. Mead, go ahead.
That looks thick enough for it.
It does.
It does. Your Honor, I submitted a brief to the court. Did the court get that?
I have right here.
Excellent. Very good. This is kind of a pretty simple three issue thing. What it is, Ms. Stewart had a hearing last year. She was seeking a return of her driving privileges. She carried her burden of proof under Rule 257-313, but the hearing officer, instead of granting her a full license, granted her a restricted license. If a restricted license is granted, you have to have an alcohol interlock device. She went and tried to she had that installed in the car, and it's simply, she could not physically make it work. Her attorney at the time filed some kind of motion for different relief, basically including all the testing from a pulmonologist showing that she doesn't have sufficient airflow to be able to blow into the machine to get it to operate. Those standards are set federally. They can't be adjusted. In Michigan, they could be adjusted here if Michigan agreed to it, but they don't agree to it. So there's no adjustments can be made to the machine. That motion by her then counsel was just ignored. Nothing happened. She left the machine in and eventually violated her for not having the power, the battery charged up. She waited out a year for that. We came back and I came with her. She once again carried her burden of proof by clear and convincing evidence, was granted. And I pointed out to the hearing officer, we brought in pulmonary function studies, CAT scans, everything else, that she could not blow in the machine. So please do not exercise your discretion to give her a restricted. It would be unusable. And basically, what would be the point of giving her another unusable restricted license? The hearing officer put forth his belief that he didn't think he could give a full license under the code. I was quite surprised by that. The first time I heard that was about 6 months earlier from a different hearing officer, but never before. The law has not been amended, and that one was in 1992. And so this is kind of a new thing. It had come up one time previously with the case of Kramer versus the Secretary of State. I took that in Ottawa County, and Judge Hulsing issued an order that indeed the hearing officer's idea that you can't grant an unrestricted license is incorrect under the code. It's a misinterpretation of their duties. I gave that to the hearing officer along with a couple orders from other hearing officers granting full licenses at full hearings. So he could see his colleagues did not believe as he did. He said that it was an uncompelling, unpersuasive argument to show his colleagues had a different idea of the law than he did. And then he ignored the circuit court's finding in the matter that was contrary to his own. This leaves Ms. Stewart once again with a restricted license she cannot use. And he said further in his appeal, well, I don't believe she carried a burden of proof for a full license anyway. There is not two burdens of proof. There's one. 27313 is the only burden of proof. There is not one for a restricted, one for a full. It's just one burden of proof and then discretion to give a restricted or a full. And so that is a mistake of law by the hearing officer yet again. And at this time, we would just ask, she's carried her burden of proof by clear and convincing evidence twice now that she is a lower minimum risk of relapse and poses no danger to the public. And I would just ask that instead of restricted privileges she cannot use, that she be granted her full license, which she could. Thank you.
All right, Mr. Butler, on behalf of the Attorney General's office today, what's your position?
Thank you, Honor. Well, Ms. Stewart's situation looks a lot like the case cited by the defense or by the petitioner, Don Kramer case. And it's frustrating because I have had the opportunity to look over everything. I do see that Ms. Stewart does have a medical situation, which does affect her lungs. I don't have any reason to doubt that. It's frustrating that we don't have, the state of Michigan doesn't have another way to then ensure that she's not consuming alcohol, because we know there's other ways, like scram, that you can do that very easily. But for one reason or another, the law is what it is, and you have to interlock and require the threat. So with that, I think she's medically unable then to do what she's being requested to do. It appears that she has jumped through the hoops that have been put forth to her by the Secretary of State. Is what she can do. She's done that, and what I tell. So with that, we would leave this in discretion, Your Honor, but it does appear that this does meet prior case law.
All right, so I appreciate the arguments. I did think it was interesting also reviewing this, that we haven't updated the statute that would allow different means of testing. I also would concur with the idea, I don't think there's any doubt that the petitioner has a medical condition as it relates to the ability to provide breast samples, but there would be nothing that would prevent the monitoring for alcohol with a scram unit. It's probably an easy fix in today's world, other than the fact it would require legislation and getting anything done in the legislature is always an interesting proposition, even if it's something that makes very good sense. And I also contrast this with what I see every day in this courtroom with people that are on supervision. This is, I guess, another form of supervision that would be civil in nature rather than criminal that I'm referring to. It's a long way the court's saying that I have less heartburn. Obviously, we can't predict future behavior. Certainly, the petitioner could continue, or I guess return, maybe it's a better word, to using alcohol and seriously injuring or killing somebody. But the chances of that occurring are far less than what we see today with the Department of Corrections, where now in our brave new world, if you will, people that are being supervised on probation and parole walk into their probation or parole office, test positive for methamphetamine, and they're not taken into custody. They get to turn around and walk right back out. Those folks are far greater risk on the road, in my estimation, because we don't do anything that they've been ordered not to use drugs, than this petitioner. So I concur with the case law that's been cited. I concur with the arguments put forth by Mr. Mead, and I'd sign an order restoring her license.
Should I put it under arbitrary capricious, Your Honor?
Well, that would probably be the easiest way to do it, I would guess. Clearly unwarranted abuse of discretion. Yeah. Okay, what do we have next?
Thank you, Judge.
Yes, if we go to active jail, Your Honor, I believe that defendant Sarah Bausma.
Are you Miss Blasma? Blasma?
Bilesma?
Is it Sarah?
Bilesma?
All right, what are we doing today, gentlemen?
So for the record, it's case number 24S18976F8, people be Sarah Bilesma. Bilesma is present via Zoom to the jail, or Mr. Franklin is present in court, today's the date time for a status conference. I have had the opportunity to talk with Mr. Franklin a bit more about the case. I have adjusted the offer a bit. The offer is for the defendant to plead guilty or no contest to counts 1 and 3. We'll dismiss count 2 for an habitual. We would kill him with a jail gap. That's the change. That offer is open for today. The PSI, probation, fines, cost, restitution, we would include count 4 of the MDOP, which in this case, no contact orders would remain.
All right, and Ms. Franklin, what's your client's wishes today?
Ms. Bilesma, you just heard the offer. It does include the jail cap, something that you and I have talked about a lot. Today is the first day the prosecution has offered that. If you want to take that today, you can. If you'd like to talk to me in a breakout room, I think we could probably arrange that as well, but it's up to you.
What's the cap? What's the jail cap?
It's just a jail cap, so it'd be.
Oh, I need a day. How many days? What's the jail cap on that?
It would be no more than 12 months, plus the credit you already have.
to plead
Oh,
guilty
minus.
when there's, okay, I just was hoping that the judge could clarify if there's evidence even against me. Because there's no injury, so I'm wondering how I'm being held
Would
against
you
for
like-
a four
Sarah, you
year
wanna talk breakout room real quick?
with no
I'm
evidence.
gonna just put you in a breakout room and then, she
Well,
doesn't
I
say
need to,
something.
I need
She
to,
should.
no, he doesn't help me. He doesn't help me. I'll just plead guilty. No contest. Because I'm not gonna win anyways. If there's no evidence even against me, there's no injury. There's no injury. How am I even in jail?
Miss Blasma, then I'm gonna place you in a breakout room. You can talk to your
My
attorney about
lawyer
it.
is not helping me, sir. I need you as a judge to
Yeah,
know.
I'm
to look at the
not your
case.
advocate, all right? I can't
He's the
advocate for
judge.
you.
If there's no evidence, how can you as a judge charge me when there's no evidence of injury?
So
How can
deputies,
you
can
charge me, judge?
ma'am, if you'd stop, I'm gonna have you talk to your attorney. Doesn't need
I
to
don't
have
wanna talk
any
to him.
injuries for these charges,
I
none.
don't want to.
Is there a
There's no
place that
injury.
she can be placed, that she can talk to Mr. Franklin while we still have the jail camera there available to continue our document? Deputy?
Yes, sir. We're working on it.
I don't want to talk to him. He's not gonna do
Okay.
me any good.
All right, well, you're gonna have to talk to him first, and if you decide that you still wanna plea, then you're welcome to come back and we'll take care of that. Mr. Franklin, they're trying to get her into a different camera so we can keep using this one. So we'll get you pushed in there as soon as we can. What else do you wanna call?
Yeah, if we can call, the case of People v. Milton Hensley, 23S18766FH. I do see that Mr. Hensley Bay is on Zoom. They set to apparently address his motion to stay.
All right, Mr. Hensley Bay, how are you this morning, sir?
I'm all right, Jan. How are you?
I'm good. So I feel like last time I saw you, we already addressed this motion, but let me flip back through the file.
Well, this motion here is at the Michigan Supreme Court. And
Let's hear, let me see, let me find it. One second.
oh, just,
I did sign an order on January 23rd. The defendant's motion to stay trial court proceedings pending appellate decision was denied. So then, on January 8th, all right, so Mr. Hensley, I think I see where we're at now. So it looks like court denied a motion to stay proceedings on January 23rd. And then there was an order from the Court of Appeals on January 26th. So 3 days later, it looks like that your claim of appeal was dismissed. And then you filed on February 9th a notice of appeal to the Supreme Court. Trying to find the exact verbiage here of your motion, the motion to stay execution pending appeal of the bond to be waived. Okay, so we can hear that quick then, sir. I do have to go through these series of questions. You probably know them by now as well as I do, but I still have to ask them all. We'll have to go through all of that, sir. So if you raise your right hand, I'll have you sworn, Mr. Hensley Bay. Sir, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
affirm.
All right, you can put your hand down. All right, Mr. Hensley Bay, as I've noted, we've gone through this several times. I just need to find our list here. But you are appearing here today representing yourself. And is that what you'd like to do today, is to continue to represent yourself on the motion that you have filed asking for a stay of the proceedings?
Yes, I do present myself, yes.
All right, but you wish to continue to represent yourself, is that accurate?
Yes, I continue to present myself, yes.
All right, and then, Mr. Hensley Bay, do you understand that representing yourself can cause you to be at a disadvantage, particularly as it relates to the people who are represented by attorneys? And recognizing that you could be at a disadvantage, you continue to wish to represent yourself, is that accurate?
Correct.
Okay. And Mr. Hensley Bay, as I mentioned before, that if you wanted to, you could ask for an adjournment. I'd actually grant you that adjournment. If you wanted to hire an attorney, are you waiving your right to go hire an attorney then?
I have outside, if I need outside counsel, I can get it. Gratitude.
Okay, but you're not requesting an adjournment to go hire an attorney and have them represent you on this motion, are you?
No, I'm not.
All right. And you also understand that if you were eligible, you could petition the court for an attorney at no expense to yourself. Are you waiving the right to request court-appointed counsel?
At this time, yes.
All right. And this, Mr. Hensley Bay, do you understand that if you go forward representing yourself again this morning, as you have in the past, that the court is going to be required to treat you the same as I would any other person appearing before the court, whether attorney or not? Do you understand that?
I do not, but
Well, when you say you do not, we've had that argument before in a motion, right? So you're referring to the idea that you thought that there was a case out there that would suggest the court has to give you a lot of deference or wide latitude because you're representing yourself. Is that accurate?
Kearney versus Hand. Yes, ma'am. Yes.
All right. And then we have debated that in the past. The court has denied that, saying that I don't believe the case stands for that proposition. And then if you go forward today, again, I'm going to have to treat you the same as I will Mr. Butler or any other representative from the people. Do you understand that?
I comprehend, yes.
Okay. And then Mr. Hensley Bay, again, I'll remind you that the charges that you're facing are serious. Those are 5 years of incarceration. That's a maximum penalty on the carrying a concealed weapon charge. Up to 4 years of incarceration on the assault, felonious assault charge. And then the big one here, this felony firearms is a charge that carries a maximum penalty of 2 years consecutive with and preceding any term of imprisonment. So again, explaining that you'll have to serve 2 years, no discretion by the court or anybody else. It has to be 2 years before you begin serving any sentence that would be associated with 1 and 2. Do you understand that those are serious penalties and that there are risks by you continuing to represent yourself? Do you understand that?
I comprehend. So the time went up on the charges, or because the last I was heard, it was 2 years. So now one is 5 years.
Count 1 is 5 years. Count 2 is 4 years, and count 3 is the 2 years consecutive to 1 and 2.
I heard nobody.
Same penalty that I've read to you over and over and over.
Yeah, I don't remember the numbers being that large, but okay.
All right, but I have to give them to you again today, like we have, and you still wish to go forward on your own. Is that accurate?
I still present myself.
Very good. Do you understand that as it relates to rules of evidence, court rules, that if you continue to represent yourself, the court will have to hold you to those rules, just as I would any other attorney appearing in the courtroom?
So is that the same as you talking about my constitutional rights when you say the court rules?
Yeah, you certainly have constitutional rights, but as it relates to the court rules, the court will have to hold you to those like I would anybody else, including attorneys. So in other words, I can't give you some wiggle room on deadlines or something like that that might be found in the court rule. I have to hold you to the same rules. Do you understand that?
Mm.
You understand that, Mr. Hudson Bay?
Can you repeat that one more time for me, please?
Sure. I'm gonna get Mr. Franklin in a breakout room here while I'm doing that. I think we got him squared away. All right, so Mr. Hudson Bay, back to the question at hand. Do you understand if you go forward today representing yourself that I have to hold you to the same standard as it relates to court rules or rules of evidence or anything else as I do attorneys? Do you understand that?
I comprehend.
Okay, then knowing that you still wish to go forward on your motion today, representing yourself? You want to go forward representing yourself today, recognizing the court has to hold you
Yes,
to the same
yes,
rules?
yes.
Okay, very good. All right.
Mm.
All right, Mr. Butler, do you believe the court's complied with 6.005?
I do, thank you.
Okay. I do find that again this morning, Mr. Hensley Bay's waiver of his right to counsel and his request to continue to represent himself has been done knowingly, intelligently, and voluntarily. It's unequivocal. And I think the court also can rely on the prior times Mr. Hensley Bay has been in this courtroom. It's been numerous. His answers have always remained the same with his desire to represent himself. He's always acknowledged that if he did need counsel, he would retain counsel, or that he would exercise his right to request court-appointed counsel. The court's also satisfied that it has, again this morning, explained the dangers of self-representation to Mr. Hensley Bay, and that he'd be held to the same standards as other members of the bar or other individuals appearing before the court. So I'll allow him to continue with his self-representation. And then Mr. Hensley Bay, you're welcome then, sir, at this time, then to give the court any argument you'd like on your motion here that appears to be a request to hold the proceedings in abeyance, a stay, pending your request for the Supreme Court to look at this matter. What would you like to state in support of your motion, sir?
Excuse me, pain. I'm coming. Yeah, I'm coming. I'm just gonna read my motion. Defense motion for stay of execution pending appeal and bond to be waived. Come now, Milton Hensley Bay, in aforementioned case with a motion to stay. Defendant move for an order staying execution of or any proceedings to enforce the final dispositions judgment entered in favor of Ione County Prosecutor Kyle Brandon Butler on January 8, 2024, pending disposition of defendant's appeal, which was filed with the Michigan Supreme Court on February 8, 2024. Defendant further moves that as defendant is indigent, no superseded bonds be required by the court, or if one is required, that no sureties be demanded. This motion is based on MCLA 600.2605 on MCR 3.604L. In support thereof, I am writing to request a stay of proceedings pending appeal in the above mentioned case. The purpose of this motion is to prevent irreparable injuries to the defendant appellant if the request stay is denied without causing harm to the appellee or the public interest if the stay is granted. Nature of irreparable harm. The denial of due process during the trial proceeding has resulted in specific irreparable injuries to the defendant appellant. The right to a fair and impartial trial is a fundamental aspect of due process under the Constitution. The denial of a continuance and the subsequent trial proceeding, which precluded critical evidence, have impeded the defendant appellate ability to present a robust defense. Denial of continuance. The defendant appellate motion for a continuance pending discovery was denied. Limiting the time available for adequate trial preparation, this denial directly infringed upon the defendant appellate rights to present a meaningful defense. Trial preclusion of evidence. During the trial, the court's ruling led to the exclusion of critical evidence sought by defendant appellate. This adversely affected the defendant's ability to mount an effective defense and deprive the defendant of a fair and impartial trial. Potential for sentencing before mandate. A particular concern is the risk that the trial judge may issue a sentence before the appellate court can issue a mandate. Such premature sentence would cause irreversible harm to defendant's appellee, as the appeal process may subsequently reveal errors or injustice in the trial proceedings. Lack of harm to appellee and public interest. Absence of harm to appellee. Granting the request stay will not cause harm to the appellee. The plaintiff appellee's interest can be protected without jeopardizing the defendant's appellant rights to a fair appeal. Public interest court consideration. Upholding due process rights is the public interest. Ensuring a fair and impartial appeal service and broaden goals of justice. And indigence of defendant. The defendant appellant is indigent and therefore should not be required to post supersede bonds. Conclusion. I formally request that the court grant a stay of proceeding pending appeal and, if necessary, waive the requirements for a superseded bond, or in the alternative, allow the defendant appellant to proceed with surety duty to indigenous. See attached proof for appellate court filing in attached exhibit. Closing. Express appreciation for the court's consideration of the motion and provide contact information for any further communication. Supreme Court case number is pending. I also reserve my right to amend this motion and more grounds to be argued or attendance. Thank you. Yeah.
Okay, Mr. Butler, what's the people's position here?
Thank you, Your Honor. This motion is very similar, not identical to what he had previously filed, so our response will be the same. The only difference is that we have received an order from the Court of Appeals, and that was dated January 26th, in which the Court of Appeals dismissed the defendant's claim for appeal. So then the defendant did file then with the Michigan Supreme Court, and that same day that he filed, the court rejected his filings. So there isn't anything that's currently filed, appropriately filed, in either the Court of Appeals or the Michigan Supreme Court at this time that I'm aware of. So we would ask that you then deny the defense now second motion for stay.
All right. So it is accurate that the motion before the court today is similar to the one that the court denied back in January 23rd of 2004. At that time, there was a motions filed in the Court of Appeals. It was the court's belief that they were premature at that time, and then a January 26th order from the Court of Appeals dismissing those orders or that request for review as not being right in essence. And then Mr. Hensley Bay has filed something with the Michigan Supreme Court. I don't know what the status of that is. The prosecutor it's been. Hold on, sir. Let me finish, and then I'll let you say what you want. And prosecutor suggested that those filings were not accepted. I don't see anything in the file whether they have or haven't, and it does not impact the court's decision regardless of what's going on here today. But if I could, in a thumbnail, identify the appeal that the request for stay that Mr. Hensley Bay filed earlier, this one today, are his attempt to have appellate review of different trial court decisions that were made during trial. And that review, again, I don't think is appropriate for any appellate court until there's a final judgment, meaning sentencing. We haven't got that far yet because of these motions. So again, I don't believe that there is any legal justification, a court rule that would suggest that the court is required to grant a stay. Court is not going to grant a stay for all the reasons I've stated on the record here, and that in essence, what Mr. Hensley Bay is attempting to have reviewed is something that can only occur after we have a final judgment, which is sentencing. And then the entire record of the trial, and motions and anything that occurred prior to that date can be reviewed then. And he'd have an appeal of right, as I've mentioned in the past, because of the verdict after trial. So it wouldn't even be the lesser request of a claim of appeal. I'm sorry, seeking leave to appeal. He'll have a right to review of the trial and all decisions that went into it. So respectfully, Mr. Hensley Bay, I'm going to deny the request for a stay here today. Mr. Butler, I'd ask that your office prepare an order indicating the same, and let's make sure so that it's easy to track, or as best we can, that the language that Mr. Hensley Bay has used is in that order. It's denying his defense motion for stay of execution pending appeal, bond to be waived. All right, that was filed on February 9th. And then Mr. Hensley Bay has promised, so I'm denying the stay, but do you have a question?
Yeah, I mean, the only reason why the appellate court, one of the reasons why they denied the motion, because I don't have the transcripts yet. And I don't have any information saying that the Michigan Supreme Court denied anything, because they
Well, that's what I said. I don't have anything either, but so here's the thing. I'm denying the request today. Now the Supreme Court, if they sign an order that says, wait, we're granting your request for a stay, then this court has to follow any orders that would come from the appellate courts. I don't have anything in the file that would suggest that.
Okay, but you do have my paperwork that I did file with the Supreme Court, and you have the numbers on everything, the date that I filed.
I have what you have titled Notice of Appeal to the Supreme Court of Michigan, and
Okay.
the case title is TBD, I assume to be determined.
Yes.
So that is in the file. It's received on February 9th.
Yeah, I can't do nothing until I get those transcripts though.
Okay, so next order of business then is Ms. Bond is here. We had a pre-sentence report completed.
No, not yet. He's scheduled for sentencing on March.
Okay, does he have a date that he's to report to?
I was gonna actually make contact with him this afternoon.
All right, so Mr. Hensley Bay, absent some direction from the appellate courts, it sounds like probation will be contacting you to begin the process of completing the pre-sentence report. And what was our sentencing date?
March 5th.
So March 5th looks like will be our sentencing date, okay? So make sure you respond to them and get that completed, because I don't want you to be violating the terms of your bond or something of that nature. And I'm not suggesting that you would, because you always appear and you're always polite and respectful. But they're gonna be reaching out to you to get that scheduled and get a sentencing date, okay, sir?
Okay.
Okay, you are free to sign off. Thank you, Mr. Hensley Bay.
All right. I come today and get that order that denial.
I didn't catch that last part. What was that?
That order that he denied, you denied. Can I pick that up?
Mr. Butler's going to prepare that order. I assume that can be done today. I'll sign it, and then it'll be filed at the clerk's office, and you are certainly welcome then to contact the clerk's office for a copy so that you have it for your records.
Okay, gratitude.
Okay, sir, you're all set today. Thank you.
All right.
What do we have next?
Yeah, if we can go back to the case of People v. Sarah Bilesma, case number 24S18976FH. She is present via Zoom from our county jail. Our attorney, Mr. Franklin, is present in court. It's my understanding that she's willing to enter a no contest plea.
All right, is that accurate, Ms. Bilesma?
Yep.
All right, and then I heard earlier that's going to be counts 1 and 3.
That will be counts 1 and 3, Your Honor. Yes, I do have amended information here as well as license rights. And we'll have the smart.
All right, Ms. Bilesma, if you raise your right hand, I'm going to have you sworn. You solemnly swear from the testimony you're about to give will be the truth, the full truth, and nothing but the truth, so help you God.
Yeah, just don't ask me if I did it.
I didn't catch that. That's just a yes or no question.
Yeah.
Okay, you can put your hand down. Ms. Bilesma, the charge in count 1 is assault with a dangerous weapon. That's commonly known as felonious assault. That's a 4-year felony and or a $2,000 fine. DNA is to be taken upon your arrest, and a consecutive sentence could be imposed if the assault was committed in a place of confinement. Now, count 3 is resisting or obstructing, thank you, a police officer. That's a 2-year felony and or a $2,000 fine. A consecutive sentence can be imposed if the assault was committed in a place of confinement or for another violation arising from the same transaction. Ms. Bilesma, do you understand the nature of those 2 charges and the maximum penalties associated with those 2 charges?
I thought we were capping and I wasn't gonna have to do consecutive.
I'm just informing you of the maximum charges. The agreement that you have with the people has already been placed on the record, okay?
Oh, it's not gonna be no like 12 months and 12 months consecutive, because I feel like I'm being tricked here anyhow.
Okay, so I didn't hear anything about a consecutive sentence as part of your agreement. Is that accurate, Mr. Butler?
They'll be concurrent.
Okay, so they said that they'll be concurrent if that was placed on the record.
Well, sure, then I'm guilty as charged.
Okay, so let's have you listen carefully to the court's question. Do you understand the nature of those two charges? Let's start with that.
Yeah,
And do you understand the maximum penalty with each? Okay, they could be up to 4 years and up to 2 years, and both of them could be run consecutive if that wasn't part of your deal. Okay, so do you understand the maximum penalties?
but that is part of my deal, right? I'm not getting any more than 12 months, right?
That's what the prosecutor just said. So if you listen carefully, you're answering your own questions.
Yeah.
Do you understand the maximum penalties?
Yes,
Okay. Ms. Bosman, do you understand that if you go forward with a plea, you won't have a trial of any kind? Is that what you want to do? Is waive your right to have a trial so you can take advantage of this agreement that's been placed on the record this morning?
yes, I'm probably coming back for prison when I violate probation, no.
All right, well, we can cross that bridge when we get to it, but that's not the best attitude to have going into supervision at some point, but we'll get there later. All right. So you don't want to have a trial. Is that what I'm hearing?
I'm not going to trial, there's no point. Yes,
All right. When you waive your right to have a trial, you waive all of these rights that I'm going to explain to you now. All right. So just listen, and then I'm going to ask you a question about it. Okay. So you're waiving the right at trial to be presumed innocent, not just of counts 1 and 3, but all the charges you're facing. You're waiving the right to confront any witnesses that might be called against you or to call your own witnesses. You're also waiving the right to testify at a trial or not to say anything, and then the trier of fact couldn't use that against you. You're also waiving the right to have the assistance of an attorney at a trial. You could have Mr. Franklin throughout a trial, and even post-trial if you wanted to go that route. Ms. Boswell, you're waiving all the rights that would come along with a trial, again, to take advantage of the agreement that was placed on the record this morning.
so, if I plead no contest, am I able to take this to an appellate court and get it out of Ione County?
Well, we're going to talk about that in 1 second.
Okay,
So are you waiving all the rights that would come along with a trial?
yeah,
Okay. 2 more things you waive by waiving your right to have a trial. The first one is this: you waive the right to claim at a later date and time, sometime in the future, in other words, you're waiving the right to claim it wasn't your choice to enter these pleas this morning. In other words, you can't come back later and say, hey, wait, on February 20th, it wasn't my choice to enter no contest pleas. It was Mr. Franklin's, or it was my boyfriend Bubba, or whoever it might be. You can't come back later and say it wasn't my choice. Do you understand that?
100% my choice. I'm willing to try to get this resolved as quickly as possible.
All right. So you understand that you can't come back later and say it wasn't your choice this morning.
It's my choice to plead no contest, yes.
All right. Here's the other thing that you waive. You waive the right to come back later, in the future, in other words, and say that there were other promises or threats or inducements to you except those we've already placed on the record this morning. Do you understand that?
Yes.
Okay. Now here's what you asked about earlier. Even with these pleas, you're going to have a form of appellate review available to you. It's called leave to appeal. And with that, you could hire an attorney to file that for you. If you couldn't afford one, you could request an attorney from the court. Do you understand that?
Oh, absolutely. That's what I will be. We're looking forward to doing. Thank you.
All right. So just because you seem anxious to do that, I'm going to then go a little further than what I'm even required to do. Do you recognize that leave to appeal means that the Court of Appeals, because you're entering a plea, doesn't have to look at it at all? They can summarily say no. You understand that?
I probably won't even file any paperwork anyways. I'm kind of like giving up anyhow at this point for any justice.
Okay, well, here's the difference. If you go to trial and you lose, then the Court of Appeals has to review your request. If you enter a plea, you can file an appeal and they can summarily say no without any review at all. So that's the difference. That change anything for you?
I know, yes, I'm gonna be sitting in here for a year just to go to trial.
Well, you're not gonna be there for a year to go to trial. If you want a jury trial, we'll get it on for the next jury selection date. That's every 3 months or something like that. So you'll have trial dates a week or so after that.
Another 3 months, or,
I don't know when my next date is. You wouldn't be on my next date, so it'd be out for our next term. So I don't know when that would be off the top of my head, but it would be probably 2-3 months at least.
yeah, 6 months, I got 12 months done here, so I'll just plead no contest.
All right, so I'm gonna go back to that question. Do you understand your right to appeal is gonna be limited because of a plea? Do you understand that?
Yeah,
All right. Now, Ms. Bosworth, let's talk about those charges, okay? Now, count 1 is assault with a dangerous weapon, commonly known as felonious assault. How do you plead to that charge?
no contest.
All right, and count 3 is resisting, obstructing a police officer. How do you plead to that charge?
No contest.
And then Mr. Franklin, the reason for these no contest pleas?
Your lack of independent recollection.
All right, the court does find that as a factual or an appropriate use of the no contest plea. And Mr. Butler, you don't have any objection to the no contest pleas?
No objection.
All right, so then I have before me what's been marked as People's 1. It is incident number 5671-23. It's a police report authored by the state police, 9 pages in length. And then there is I guess it's just 9 pages in length. Mr. Franklin, do you have any objection to the court receiving 1?
No objection.
Court will receive 1. Just give me a minute to review it. I do find factual basis for 1 and 3. Also do find it confirms venue as related in the information, Alliance Township, County of Ionia, and our date and time of on or about October 13th of 2013. Mr. Butler, anything else on the facts?
No.
Mr. Franklin, how about you?
No, you're not.
All right, Ms. Boswell, I'm back to you. Other than what we have talked about here this morning on the record, has anyone else promised you, threatened you, or done anything to you to get you to enter this plea?
No, sir.
Okay, other than what we have placed on the record this morning, has anyone else said anything to you about what your sentence will be as a result of entering these pleas? And I'm not talking about Mr. Franklin, that's his job. I'm talking about, has anyone else said anything to you, like your aunt or your bunkie in the jail there, or somebody else? Has anyone else said anything to you about what to expect for a plea or a sentence?
Nobody cares, sir. The only 2 people that care are my kids. They don't
All right,
know.
but they haven't said anything about what your sentence might be?
They wouldn't know.
Okay. Mr. Butler, are you aware of any other promises, threats, or inducements to Mr. Bowser?
I'm not.
Mr. Franklin, how about you?
I'm not.
Mr. Butler, you believe the court's complied with the court order for taking the no contest plea? Mr. Franklin?
The court has.
Okay, Ms. Bosman, do you have any questions about anything that we've covered now that we're just about done with this process?
Nope.
All right, last question. Do you want the court to accept your no contest pleas to 1 and 3?
Yep. Yes.
I'm sorry, I didn't catch that.
Yes, sir.
Okay, I will accept your pleas. You did offer them freely, accurately, and voluntarily. So what will happen next, ma'am, is somebody from probation will be contacting you to begin the process of completing this pre-sentence report. Once that's completed, Mr. Franklin's gonna get a copy of it, and he's gonna go over it with you the day or 1 or 2 days, maybe the morning of, before sentencing. And that's so that the 2 of you can review it and check it for accuracy. All of that will occur And then sentencing is generally going to be about 4 weeks out. All right. So I'll see you in about 4 weeks. Okay, if there's nothing else, that'll conclude the matter.
Thank you.